Lordship, I beg to mention item number 9 and 10. We have taken consent from the other side, item 9 and 10. Kindly adjourn this matter.
You have 40,
For the appellant.
item 10.
9 and in 10.
Your good name?
8 Talukdar, Arunab Taluk.
On request made by Ed Kalukar, Learned Counsel for the appellant in criminal appeal 336 of 2018. List the matter after how long do you want?
Lordship, after 4 weeks.
Jahan, 4 weeks?
Yes, otherwise it's a debt reference, so needs to be heard little early.
Yes.
So, any?
Make sure.
As your Lordship pleases.
4 weeks. Yes.
Highly obliged.
Please, your Lordship.
Yes.
Your Lordship, beg to mention item 13 and 14 of today's case, your Lordship. Your Lordship, may I pray the matter may be adjourned today, and if it is not inconvenient, can it be fixed on the next week, any date next week?
Okay.
9th or 11th?
On request made by R. Sharma, Learned Amicus Security. List the matter on 11.
11th. Nice, your Lord.
My please, Lordship.
Yes, please.
Lordship, I beg to mention item number 8 of the Delhi list.
Yes.
May the matter be kindly be adjourned for the day.
Your good name, please.
K. Helungla, Lordship.
You are appealing on behalf of?
The appellant,
No, which council?
as per Gohain.
On
We have taken the consent of the other party and given the adjournment slip.
behalf of West Bogohan, Learned Counsel for the appellant. List the matter after?
2 weeks, my lord.
Okay.
Lakshmi.
Item 1 of daily leave admissions.
Please, your Lordship.
Mm.
Lordship, it's a conviction, appeal against a conviction, Lordship. Conviction under
Section 6.
under section.
Coming up for the first time.
Yes,
Lordship, under section 6.
20 years.
20 years,
conviction.
Lordship.
Part MS.
SK Nargis, my name is not showing in the cause list, Lordship, but it is in the Wakalatnama and
SK
Nargis, Lordship.
Nargis.
That should be shown in the cause list, Lordship.
Learned Counsel for the appellant. Admit call for LCS. MS El Jahan, Learned additional PP. Appears on behalf of
1.
respond number 1. Appellant to take steps for service of notice on respond number 2 by registered post AD within 1 week from today. List the matter after 4 weeks.
I is there, Lordship.
Registry is also directed to reflect the name of Mr. S.K. Nargis, Learned Counsel in the cost list.
I is there, Lordship.
I 2 weeks.
I heard Ms. S.K. Nargis, Learned Counsel for the applicant. S. Jahan, MSS Jahan, then additional PP, praise for 2 weeks time
2
to
weeks.
file object. There is a lot. List after 4 weeks.
Obliged.
Please, your Lordship. Statutory appeal against conviction dated 21/2023 passed by Special Judge Posco convicting the
Your good name, please.
A. Bhattacharjee, Lordship.
Bhattacharya, Learned Counsel for the appellant. Admit call for LCS. MSF Jahan and additional PP. Appears on behalf of
1.
Page number 3, Lordship.
respond number 1.
Yes, one.
Appellant to take steps for service of notice on respond number 2 by registered post AD within 1 week from today.
Lordship, there is a IA.
List after 4 weeks. Same
Same.
order.
All right.
My lord, this case released to the appeal against the conviction, my lord. Case was already admitted, my lord, and paper book, my lord, are supposed to be made.
LCRs have come,
Yes, my lord. LCR and notice is also complete.
heard Mr. Jia Bagwell and the council for
There's
that.
only one last one. Okay.
Also heard MSS Jahan. LCR have been received, registered directed to prepare the paper book and list the matter of the four weeks.
They have entered appearance for the response.
Mr.
As they, your lord.
S. Dale, then the council appears on behalf of respond number
2, 3, and 4, your lord.
Paid respondents.
2, 3, and 4.
Objection copy to this. May it please your lordships. Lordship, this is, we have filed an IA. IA is for consideration today. Yes. And we have made a small compilation of the evidences.
Jahan, you have filed your objection?
Yes, yes,
Objection
I
is
filed,
made.
I've given the copy to them. I hope it's there in the records.
No.
Oh, I
Filed
filed
on.
it long back.
Get to some- get to some-
Yes, I filed it,
1 minute.
I don't know what. I filed it long back. It's not tagged perhaps in the
Yeah,
section.
you have a copy? No objections. No.
It was filed in, I guess, March.
March, yes.
Okay. We'll direct them to list it,
Yes.
place the copy in the I. Heard Mr.
DK Bhattacharya.
DK Bhattacharya, legal counsel for the applicant.
Yeah, record of law.
MSL Jahan and the addition PP Assam submits that she has filed your objections in the month of
March.
March 2023. So registry to verify and verify on the report. And this will matter after 1 week.
One.
March.
And if a date can be fixed.
Let's see.
Right.
Not much cases.
Five, I had on the last occasion took time to file affidavit, the objection. But perhaps I missed it. If your lordship takes it up next week, the I.
My lord, otherwise, my lord, I am only paying for applicant number 2, C is 78 years old, my lord. For applicant number 1, I am not paying.
Age is not a factor.
My lord,
Let's see whatever is that.
Hmm.
Heard Mr.
RS Mishra, my lord.
R.S. Mishra, legal counsel for the applicant. On request made by S. Jahan and the additional PP. This is after 1 week to enable her to file. Which March.
Obliged, your lord.
6,
My lord, this is an appeal, my lord, against conviction under 302, my lord. In preferring the appeal, there has been a delay. That is how, my lord, this miscase.
How much
127 days, my lord.
Jahan?
No,
I am appearing as a legal aid counsel, my lord.
No objection.
Okay. In the area. Heard Mr. Tia Sharma.
Yes.
Legal aid counsel applicant for the applicant. But this also heard from Mr. Jahan. This is an application for continuation of 127 days. In filing. Stop. We have considered the course shown in the present application. And we have satisfied. Unless it's done and mentioned, has also no objection. According to delay of 127 days, is condoned. IAS accordingly disposed of. Registry directly to number the signal at. This the matter. We will want.
Obliged.
seven,
Where's the sound coming from? From here.
May I please your lordship.
Yes,
But here the appeal will not yet admitted, my lord. So appeal may be admitted, my
appeal not admitted.
lord. Yes, but perhaps wrongly they have listed the IA. The first
What-
time
what
case is
this
listed.
IA about?
I is
Yes,
389.
my lord, 302, my lord, life conviction here.
I is for suspension.
Suspension.
Yes, my lord.
File my objection.
Yes, my lord. So appeal may be admitted and call for the LCR, man.
Where's the comment first time?
Yes,
Oh, it has come up for the first time.
first time the case is listed.
You are Mr.
And Uddin.
Anuddin, heard Mr. Anuddin, learned counsel for the appellant in the criminal appeal. Huh? In the criminal appeal. Stop. Admit call for LCRs. MSS Jahan and additional PP. Affairs, Assam appeals on behalf of the respondent number 1. Appellant to take steps for service of notice on respondent number 2 by registered post ID within 1 week. Stop, list the matter after 4 weeks.
Same order in I also, my lord. I will take
I
this.
use the same usual logic. You want to file objections?
Yes, yes, 2 weeks.
After 4 weeks.
I am obliged. my lord.
Item 11, hearing.
In this matter, Mr. K. Goswami is the appointed amicus senior counsel. He's just on his way, my lord. My lord may kindly pass over the matter for the time being.
Now,
He's about
how
to reach.
many matters are there now?
Only one matter is left.
Oh.
On 2, of course, 1 in supplementary.
He's about to reach. Hold on.
Okay,
Oh,
call off
just
the
need-
other object.
12,
Obliged, my lord.
Mr. Andrew does it again, like yesterday. But Mr. Goswami will come.
This is not mine. Oh,
Councils, perhaps they think the matter will reach little late and so they come late.
they should be early. 8:30 court starts. None appears for the appellant. MSS Jahan and additional PP appears for the state of Assam. List again up to 2 weeks.
fifteen of supplementary list, hearing.
Lordship, that LCR has to be sent back, Lordship. That part is,
That's the reason why we have.
yes,
Oh.
Lordship.
today.
Acha, acha.
We, by inadvertence, we forgot to mention. Send on the LCRs. Heard MS B Sharma, Leonard amicus curiae. Also heard MS S Jahan, Leonard additional BP Assam. By order dated 28/4/2023. This court had directed the learned sessions judge Baksha Musalbu to examine 2 witnesses, 2 persons, namely Diba Khachung and Gita Hachung, within a period of 1 month from the date of receipt copy of the order. However, due to inadvertence, LCS no direction was given for remanding back the LCS to the learned judge Baksha. So accordingly, registry is directed to send down the LCS to the learned sessions judge Baksha Musalpu. Thereafter, the learned sessions judge shall proceed in terms of the order dated 28/4/2023.
Okay.
List the matter after
6 weeks.
6 weeks.
Seven,
11 is there. I thought I'll start see. So till he comes back.
I'm sorry, my lord. I have miscalculated the timings. I thought there were two parters. That's what I thought, but probably it got adjourned. But here I'm appointed as an amicus curiae. Now, this is a case where, as per the FIR, the wife was burned by her husband, and because of the burned injuries, she ultimately died. The case is on circumstantial evidence. There are about 10 PW witnesses, and the accused himself also was examined. The case is otherwise on circumstantial evidence, primarily on the dying declaration, where the wife, the victim, had told to her relatives, PW2, PW3, and PW4, that the husband had burned her with kerosene in the kitchen. And she reiterated the same before the police officer in the hospital. Now, if I may just take your lordships through the evidences. Before that, just crucial dates. The date of occurrence is 15/4/15. The date of FIR is
Occurrence is
15/4/2015. FIR was lodged on 21/5/2015 by PW2.
that is the
Date of FIR by PW2, who is the brother of the victim. And ultimately, she died on 26/6/15.
twenty.
26/6/15.
Oh.
After about a month's time. Now, your lordship will kindly come to the
Yes,
FIR.
the
Yes, I am straight away taking your lordships to the FIR, which your lordship will find at page 4. Page 4, has your lordship got it?
yes.
With due respect, I would like to state that my sister Rita Mura, married with Lodha Mura, LS Sanjeev Mura, resident of so-and-so, sometime 3 years ago. Out of the said wedlock, one girl child was born who is aged about 2.5 years. Since after the marriage, Lodha Mura used to torture physically and mentally always, but somehow my sister is tolerating this for the sake of her conjugal life. But on 15/4/15, Lodha Mura poured kerosene oil on the body of my sister and ablaze her in fire. Immediately after hearing hue and cry, some neighboring people came and rescued her. She was sent to Dibrugarh for treatment. Due to business in her treatment, we could not able to file the FIR Ijahar immediately at the time of accident. Now she is under treatment at St. Luke's Hospital, so-and-so. I therefore request you to take appropriate legal action. This was lodged by brother PW2. Now, PW1 is the doctor who conducted the post-mortem. The first part your lordship will find, as your lordship got it, PW1 at page 9. On 26/6/15, I was working as so-and-so, and on that day I conducted post-mortem. The rest may not be very relevant. Your lordship may kindly come down to the opinion column. In my opinion, the death was due to septicemia as a result of more than 35% of burned body surface area with infection. All the injuries were antemortem in nature. So the post-mortem confirms that death is because of burn injuries. During cross, your lordship will find the next page. It cannot be ascertained if proper treatment was provided to the victim. She would have been survived. A question was put. Accordingly, this is the answer. Sustaining more than 25% burn in the adult is always considered as serious. It is not a fact that 35% burn injury is not a major burn injury, and if the proper treatment was provided to the injured, naturally she would have should not have died. Next, PW2. PW2 is the brother and the informant. May I read it? Deceased Rita Mura was my sister. Accused Sanjeev Mura is the husband of Rita Mura. Accused Sanjeev Mura is also known as Lodha Mura. She died nearly 1.5 years back. One day, my sister informed me over phone and told me to take her back. Then I went to her house and found her in burnt condition. Burn injuries were seen over her entire person. She told me that accused Sanjeev Mura had burnt her by pouring kerosene oil. Lordship may note that. Then I took her to St. Luke's Hospital and got her admitted there. I lodged the Ijahar immediately after admitting her in St. Luke's Hospital. I came to know that there used to be frequent quarrel in between the husband and the wife for money. Exhibit 2 is the Izahar, so and so is my signature. The Izahar was scribed as per my version as stated by deceased Rita. My sister died after 1 month of her admission in the hospital. Now during cross, your lordship will kindly see. At the time of incident, I was at my home. The deceased used to reside at so-and-so Gao. Immediately after the incident, she was first taken to AMCH Dibrugarh. 1 month after her release from AMCH Dibrugarh, she made a telephone call to me. So, my lord, what has happened? 15th is the date when PW2 comes to know about the incident. Therefore, they say date of occurrence is 15/5. Otherwise, 1 month before that only the incident has happened. And initially, her husband took her to Dibrugarh Medical Hospital. And she was there for some day and then she was brought back home because the husband did not have the financial conditions to support, to go through the treatment. This is what comes out through the evidence later. So this is after 1 month, she calls her family and then she was again taken back to the second hospital, that is St. Luke's. This, I'm just giving the background, my lord. 1 month after her release from AMCH Dibrugarh, she made a telephone call to me. Accused has another wife prior to marriage of my sister, and that is why there used to be quarrel in between the deceased and the accused. I do not know where from the Ijahar was scribed, but it was not scribed through so-and-so. I put my signature and so-and-so. Then PW3. PW3 is the brother-in-law of the deceased.
Yes.
Yes. Deceased Rita Mura is my sister-in-law. Accused Sanjeev is the husband of Rita Mura. She died nearly 2 years after her marriage with the accused. The accused and the deceased used to quarrel frequently between each other. One day, my wife received a phone call from the deceased Rita Mura that she got burned injury and she was required to be taken to hospital. She was taken to St. Luke's Hospital. Thereafter, I also went to see her at St. Luke's Hospital. I saw her in complete burnt condition. She told me, she told that she was burned by her husband. Your lordship will kindly take note of that. Prior to taking her to St. Luke's Hospital, she was first taken to AMCH Dibrugarh by the accused, and from AMCH, she was again taken back by her husband without getting her cured due to shortage of money. She remained in St. Luke's Hospital for about 1 month, where she died during treatment. Police came and took the dead body for postmortem. At the time, during cross, my lord, at the time of the incident, the deceased was residing at so-and-so. I cannot say the distance between my house and the house of the accused, as I never visited the said Gao. As such, I cannot say regarding the quarrel in between the accused and the deceased. I did not visit so-and-so Dibrugarh to see the deceased, as at that time I was unaware about the incident. On the very date of admission of the deceased in St. Luke's Hospital, I went to see her. The deceased told me in the St. Luke's hospital that the accused set her on fire. Your lordship will kindly note that. It is not a fact that I did not state before the police that deceased told me in the St. Luke's hospital that accused set her on fire. Perhaps this was not stated before the police during 161. Now, so far, PW2, PW3 consistently said that the deceased has told them that she was put on fire by the husband. And they both have also said that they quarrel, the quarrel part. And PW2 further goes ahead and says that the accused has another family, because of whom there used to be quarrel between accused and the deceased. Now, PW4 is another brother-in-law of the victim. The deceased Rita Mura was my sister-in-law. I know the accused Sanjeev Mura, who is the husband of the deceased. I also know the informant Kailash Orang. On 15/4/15, one of my relatives informed me that Rita Mura has sustained burn injuries on her chest, face, and hands. Accordingly, myself, accompanied by Kailash Orang and other family members, had gone to the house of the injured. We found the injured lying on a bed. I asked the injured as to how she sustained those injuries. Initially, she was reluctant to disclose, but later on told me that her husband poured kerosene oil upon her and set her ablaze. The PW4 also confirms. At that time, her husband, Sanjeev Mura, was not present in the house. When we had gone to the house of the injured on 15/4/15, already 15 days have elapsed after she was ablaze on fire. My house is situated at a distance of about 20 kilometers away from the house of the deceased. On 15/4/15, I was informed by the injured that after the occurrence, she was treated at AMCH, but later on she was brought back home. On 15/4/15, we decided that the injured should be admitted in hospital, and therefore Kailash Orang, accompanied by myself and other family members, brought the injured to St. Luke's Hospital, Tinsukia. After 3 days, police came to the hospital on the basis of an ijahar that was earlier lodged by Kailash Orang. I was present at the hospital at that time. Police recorded statement of the injured. After being treated for 10 days at St. Luke's Hospital, the deceased had succumbed to her injuries there. Police conducted inquest upon the dead body of the deceased in my presence. Exhibit so-and-so is the inquest report and so-and-so is my signature. During cross, my lord. Police never recorded my statement. I do not know how many days prior to 15/4 the injured was admitted at AMCH. When I first saw the victim on 15/4, her injuries were bandaged. She was not in a position to move. I was told by the victim that immediately after the occurrence, she was taken to AMCH. She was admitted there for 15 days. When the injured stated to me that she was burned by the accused, at that time, Jiten Orang, his son so-and-so, wife of so-and-so, and the sister of the injured were present. Witness final list. It is not a fact that on 15/4/15, the injured Rita Mura never stated before me that her husband had burned her after pouring kerosene oil upon her. It is not a fact that since the deceased was my relative, I have deposed false evidence for her sake. Now PW5. So PW4 also admits, basically corroborates PW2 and 3. Then PW5. PW5 is the nephew. Nothing substantial, but I will just read it. So-and-so is my maternal uncle. The deceased Rita Mura was the sister of Kailash Orang. The accused is the husband of the deceased Rita Mura. The occurrence took place about 2 years ago. One day, Rita Mura was admitted to St. Luke's Hospital, and my mother gave me the information. My mother also told me that Rita had a quarrel in the house, and for that matter, she was burnt. I do not know who burned her. He comes to know from his mother. The deceased Rita Amura was married to the accused who used to reside at so-and-so. I came to know that immediately after she was burnt, she was taken to AMCH Dibrugarh. The accused brought back Rita Amura from AMCH and kept her in his residence. My parents went to the house of the accused and took Rita Amura to St. Luke's Hospital. She died at St. Luke's Hospital after 1 week. While she was in the hospital, I visited her. Rita did not tell me who caused burn injuries to her. Police conducted inquest on the dead body of the deceased in my presence. So-and-so is the inquest report. So-and-so is my signature. I do not know when Rita was married to the accused. Before her marriage to the accused, Rita was married to another person. I did not attend the marriage of Rita and the accused. I do not know when Rita was taken to AMCH, but after her return from AMCH, she stayed in her house for 2 months. And after that, she was admitted to St. Luke's Hospital. I do not know for how much time Rita was admitted at AMCH. I put my signature on Exhibit 3 in my mother's house. My father so-and-so and elder maternal uncle so-and-so also put their signatures. Next is PW6, my lord. He's a neighbor who has become hostile. PW6, hostile witness. I do not know Kailash Orang. I know the accused Sanjeev Mura. His house is near my house. Whenever he calls me for some work, I used to go to his house. I knew his deceased wife. I have heard that she was burned to death. After she sustained burn injuries, Rita was taken to AMCH, and after that she was again brought home, where she stayed for some days. After Rita was brought home from AMCH, I went to the house of the accused. He told me that he ran out of money and therefore brought his wife back home. I did not talk to Rita Mura. The occurrence took place about 2 years ago. Police did not interrogate me. The witness is declared hostile with the prayer of the prosecution, and prosecution is allowed to cross-examination the witness. Now, the cross by prosecution. It is not a fact that I had stated before police that on 15/4/15 at about 6 p.m. the occurrence took place. It is also not a fact that I had stated before police that initially the accused and his wife had an argument and a commotion was created. It is not a fact that I had stated before police that after hearing the commotion in the house of the accused, about half an hour later, I came out of my house and saw at the doorstep of the accused, Rita Mura was lying in a burned state. It is further not a fact that I had stated before police that the neighbors dozed the fire of the body of Rita, and thereafter an ambulance came and Rita was sent to the hospital in the said ambulance. So this which he stated before the police, now he doesn't support his statement. Initially, he stated before the police that he heard the accused and the victim quarreling. After some time, when he comes out, he finds the wife in burnt condition at the courtyard. Today, later on, before the court, he does not support the same statement, my lord. Now, PW7 is another neighbor who again has turned hostile. PW7 neighbor, hostile witness. Durga Munda. He also says the same thing. He also did not support the statement that he made before the police, which was to the same effect of PW6. If I may just read it, my lord. I do not know Kailash Orang. I know the accused Sanjeev Mura. I know Rita Mura, who was the wife of the accused. The house of Sanjeev Mura is situated behind my house. Rita Mura is no more. About 2 years ago, she died. At the time of occurrence, I was at my residence. When I returned home, I came to know that Rita Mura sustained burn injuries. I came to know about that the sustaining injury, she was taken to Tinsukia and then to AMCH Dibrugarh. She died after 10 to 15 days. So some improvement here. It says initially taken to Tinsukia Civil Hospital and then to AMCH Dibrugarh. And later, as we have seen, later she was taken to St. Luke's. The witness is declared hostile with the prayer of the prosecution, and prosecution is allowed to cross-examine the witness. Now, during cross, my lord, it is not a fact that I had stated before police like this. On 15/4/15 at about 6 p.m., the occurrence took place. At that time, I was passing by the house of the accused, and then I heard that accused was arguing with his wife. Sometime later, when I returned home, I heard that there was a commotion in the house of the accused. I came to know that Rita Mura had sustained burn injuries. After some time, villagers called an ambulance and Rita Mura was taken to the hospital by the accused and some other people. So here he said before the police initially that he heard the quarrel, that part, and later he doesn't support that sentence. Next, your lordship will get is PW8, who's also a neighbor. I know the accused. I often go out for work in the morning and return home late at night. The occurrence took place at about 3 years ago. On one day, I came to know that the wife so-and-so was taken to the hospital. I have also heard she died. I do not know when she died. Cross declined. Then PW9. PW9 is the uncle of the accused who has also turned hostile. The accused Sanjeev Mura is my nephew. I know his wife Rita Mura. I know nothing about the occurrence. The witness is declared hostile with the prayer of the prosecution, and prosecution is allowed to cross-examine. Now during cross. It is not a fact that I had stated before police like this. On 15/4/15 at about 6 p.m., the occurrence took place. There was a quarrel in the house of the accused. I came to know that the accused was having a quarrel with his wife. During that quarrel, the body of Rita Mura caught fire. Later on, the villagers dozed the fire and called an ambulance. Within half an hour, the ambulance came and in a burn condition, Rita Mura was taken to the hospital. The accused so-and-so also accompanied the injured Rita Mura in the ambulance. So from the evidence of PW9, it appears accused was also there. The presence of the accused.
Cannot be 15/4 because 15/4
the doubt-
is the second,
correct.
no?
15/4, something is wrong with the date.
Yes.
The learned PP is right because 15/4, as I informed your lordship, 15/4 is the date when PW2 gets a call from her. And PW23 says that 1 month, the incident actually had happened 1 month earlier. So there is now there's some Assamese vernacular to Silobison about.
It's in
So
English.
therefore, there's something wrong about the date possibly.
It cannot be 15.
It cannot be 15/4 because by 15/4, the incident already took place. She already went to AMCH Dibrugarh and she came back. Probably after coming back and getting consciousness, and when her husband is not around, perhaps that is the time she must have tried to reach out to her family, because she called her brother and her sister. And that is how the brother-sister comes, and then she is taken to St. Luke's Hospital. And ultimately in St. Luke's, she tells her brother. And in fact, before going in the house also, she tells her sister that her husband had put her to the fire.
In 161, it's 15/4 only.
15/4. There's some that I don't know why.
The facts are not very consistent.
In
Because
fact,
by 15, there is no evidence on record that there was a second incident of burning again.
in fact, to my horror, my lord, I don't find any documents showing that she got treatment in Dibrugarh. Generally, if a patient in burn condition, and that too in a government hospital, there must be some papers. They should have informed the police. No, Julie.
Oh,
They should
yes,
have
even
informed
in
the police
case diary,
because
I don't find.
This only comes to know from the brother. Nothing before that. So that there is some gap. And there is no explanation. In fact, I will take your lordship now through the IO's evidence. The IO also doesn't call for any documents from Dibrugarh Hospital. That should have possibly been done because that would have clarified the situation. Because clearly the witnesses are saying that before 1 month she was taken there. And then the hostile witnesses are saying as if the incident happened only on 15/4. That is the day when the PW2 comes to know. So there is some confusion as regards that. Anyway, my lord, let me carry on. Let me complete the evidences. We are at page 23, the uncle of accused who has also turned hostile. I was about to read the cross. May I just read that, my lord? It is not a fact that I had stated before police like this. On 15/4/15 at about 6 p.m., the occurrence took place. There was a quarrel in the house of the accused. I came to know that the accused was having a quarrel with his wife. During that quarrel, the body of so-and-so caught fire. Later on, the villagers dozed the fire and called an ambulance. Within half an hour, the ambulance came and in burn condition, she was taken to the hospital. The accused so-and-so was present. Now, the IO at page 24. PW10. May I please advance? On 21/5/2015, I was the inspector in charge of Panitola outpost. On that day, Sri Kailash Urang had lodged an ijahar in the Tinsukia PS alleging that his sister was burned by her husband. So here the date of FIR, your lordship will find the information was lodged on 21/5/15. The OC Tinsukia PS registered the case being Tinsukia PS case number so-and-so under section 4988, 326 and 307 of the IPC. And I was given the task of investigation of the case by the then OC so-and-so. Exhibit 2 is the said Izahar and Exhibit 2.2 is the signature along with endorsement of so-and-so. And I am acquainted with his handwritings. After taking up the investigation of the case, I visited the place of occurrence on that day at about 12:30 p.m. I recorded statement of witnesses, namely Lengra Mura, Durga Munda, Suresh Mura, and Haino Mura. I prepared a sketch map of the PO. Exhibit 4 is the sketch map and Exhibit 4.1 is my signature. I arrested the accused on that day and forwarded him to judicial custody. On the same day, I came to St. Luke's Hospital, Tinsukia, to see the victim. I recorded the statement of the victim there. On 26/6/15, I received an information that the victim died in the said hospital. Thereafter, I made an application to add section 304B of the IPC in the instant case, and the said prayer was accordingly allowed by the court. On 26/6/15, I had recorded statement of witnesses, namely Deepak Orang, Krishna Orang, Jiten Orang, and Sopon Orang. After collection of the postmortem report and on completion of investigation, I filed the charge sheet against the accused. Exhibit 5 is the charge sheet and Exhibit 5.1 is my signature. During investigation, I had recorded the statements of Lengra Mura, PW6, and this witness stated before me that on 15/4/15 at about 6 p.m., the occurrence took place. Here also, even the IO confirms the date as 15/4. The occurrence took place and initially the accused and his wife had an argument and a commotion was created. Lengra Mura stated before me that after hearing the commotion in the house of the accused, about half an hour later, he came out of his house and saw that at the doorstep of the house of the accused, Rita Mura was lying in a burned state. This witness also stated before me that the neighbors dosed the fire on the body of Rita, and thereafter in an ambulance, Rita was sent to the hospital. Exhibit 6 is the statement of Lengra Mura recorded by me, and Exhibit 6.1 is my signature. So that part of the hostile witness is put before the police, and he confirmed that that statement was made to him. Then the witness Durga Munda, who is PW7, had stated before me like this. On 15/4/15, at about 6 p.m., the occurrence took place. At that time, I was passing by the house of the accused, and then I heard that the accused was arguing with his wife. Sometime later, when I returned home, I heard that there was a commotion in the house of the accused. I came to know that Rita Mura had sustained burn injuries. After some time, villagers called an ambulance and Rita Mura was taken to the hospital by the accused and some other persons. Exhibit 7 is the statement of Durga Munda recorded by me, and Exhibit 7.1 is my signature. Then the witness PW9, Malak, that the uncle, Bhaya Mura, stated before me like this. On 15/4/15 at about 6 p.m. the occurrence took place. There was a quarrel in the house of the accused. I came to know that the deceased was having a quarrel with his wife. During that quarrel, the body of Rita Mura caught fire. Later on, the villagers dosed the fire and called an ambulance. Within half an hour, the ambulance came, and in a burn condition, Rita Mura was taken to the hospital. The accused so-and-so also accompanied the injured Rita Mura in an ambulance. Then it will be about 6 kilometers between the PO and the Panitola outpost. On the other hand, in the printed form of FIR, it has been stated that the distance between the PO and the Tinsukia is about 6 kilometers. In the diary, it has not been mentioned the distance between the place of occurrence. Our outpost is nearer to the PO than the Tinsukia police station. Prior to 21/5/15, we did not have any information about the occurrence. This is kind of little strange, my lord. Generally, whenever, as I said, my lord, a burnt victim is is brought to a hospital, as I understand, an information has to be sent to the police station. Anyway, my lord, here she has admittedly from the records from the prosecution witness, it appears she has almost gone to 3 hospitals. To Tinsukia Civil Hospital first, to AMCH Dibrugarh first, a second, and then finally to St. Luke's Tinsukia. And the police only comes to know on 21/5 when the FIR was lodged by PW2. No information prior to that, as it appears. If I may just continue, my lord. The occurrence of this case took place on 15/4/15 and the Ijahar was lodged on 21/5/15 about more than 1 month. After more than 1 month. In this regard, we have not received any information from any hospital regarding any treatment being given to Rita Mura for sustaining burn injuries. So no information from any hospital. I did not seize any medical documents from St. Luke's Hospital regarding treatment given to Rita Mura. Some witness of this case told me that after the occurrence, the victim was taken to AMCH Dibrugarh. And there she was given treatment for about 15 days. But I did not go to AMCH Dibrugarh to collect medical documents pertaining to treatment given to Rita Mura. This is what I was telling your lordships. I visited the PO on 21/5/15 at about 3 p.m. and I prepared the sketch map at about 3:15 p.m. Thereafter, I recorded the statements of witnesses. Later on, the witnesses stated that I visited St. Luke's Hospital on 21/5/15 at about 12:30 p.m. and thereafter I visited the PO. At about 11:15 a.m. on 21/5/15, I took up the investigation of the case. At the time of inquest, the dead body did not have any bandages, etc. on the body. I had recorded, this your lordship may kindly note, I have recorded the statement of the victim Rita Mura at 12:30 p.m. on 21/5/15. I obtained permission from the hospital authority for recording statement of Rita Mura. In my diary, I have not mentioned as to who are the persons present there at the time of recording statement of the victim women in the hospital. It is not a fact that I did not record the statement of Rita Mura in the hospital on 21/5/15, and that is why I have failed to state the names of persons who were present there at the time of recording statement of Rita Mura. I did not seize any burnt wood, kerosene, gallon, etc. from the place of occurrence. I had recorded the statement of PW2 at St. Luke's Hospital on 21/5/15 at about 1:15 p.m. The witness Kailash Orang did not state before me that his deceased sister informed him that the accused had burned her by pouring kerosene oil. Well, this is PW4. Kailash Orang is PW2. So here it says that during 161, he did not say. The witness Deepak Orang did not state before me that deceased Rita Mura informed him at St. Luke's Hospital that the accused set fire on fire. Deepak Orang is which one? PW3. So he also during 161 did not say that part, my lord. So PW2, PW3 both during 161 did not say it, but in witness box says that the sister have told. I did not go to AMCH Dibrugarh for investigation of the case. It is not a fact that deceased Rita Mura did not die because of sustaining burn injuries. Rather, she died because of medical negligence. Then PW10.
Further exam.
Huh?
Further exam.
This is further examination of PW10. The deceased in this case was Rita Mura. On 21/5/2015, she was alive and she gave a statement to me at St. Luke's Hospital. I was recording the statement of Rita Mura. Shanti Orang, the mother of Rita Mura, was present there. There was one staff nurse, but I could not record her name. Rita Mura stated before me inter alia that the accused had poured 1 bottle kerosene oil upon her, and with the help of a burning wick lamp, she was burned. She also told me that immediately afterwards, fire engulfed her body, and at that time, one Lodha pushed her out of her house. One Lodha, my lord, Lodha is her husband. The victim also stated before me that she shouted for help, but she lost consciousness. She stated that she regained her consciousness next day while she was in the hospital. The victim further stated before me that thereafter 4 or 5 days, Lodha brought her from AMCH Dibrugarh to her house. Exhibit 9 is the statement of Rita Mora. Now during cross, on 21/5/15 at about 12 noon, I went to St. Luke's Hospital for recording statement of Rita Mora. She died on 25/6/15. The time of death is not mentioned in the CD. I did not record the fact that there was a nurse present while I was recording the statement of Rita Mora. It is not a fact that I have deposed false evidence by stating that at the time of recording, there was staff nurse present. At the time of recording statement of Rita Mora, except her face, the remaining part of her body was covered. I did not take any certificate from the doctor, which might have certified that the victim was in a sound state of health and was fit for giving statement. Before recording the statement of the victim, I took verbal permission from the doctor, but I have not mentioned it in my diary. I did not take any signature of any doctor in the statement of Rita Mora. It is not a fact that today I have deposed false evidence by stating that Rita Mora had stated before me like this, in quotes, my lord. The accused had poured 1 bottle kerosene oil upon her, and with her help of burning wick lamp, she was burned. She also told me that immediately afterwards, fire engulfed her body, and at that time, one Lodha pushed her out of her house. The victim also stated before me that she shouted for help, but she lost consciousness. She stated that she regained her consciousness next day while she was in the hospital. The victim further stated before me that thereafter 4 or 5 days, Lodha brought her from AMCH Dibrugarh to her house. Now, your lordship will find her statement at page 69. If I may just straight away take your lordships to page 69. Statement of the victim, Srimati Rita Mora, 30 years, as your lordship's got it. My name and address are mentioned above. I got married with Lodha Mora 3 years ago and have been living in the house of Lodha at so-and-so Gao. A few days after the marriage, Lodha started to assault me. Occasionally, he sent me to my mother's house to bring money and other articles. If I fail to do so, he tortures me over tiny matters. Around 6 p.m. on 15/4/15, the incident took place. I was busy in the kitchen. At that time, Lodha arrived home and started abusing me over a small issue. When he started breaking the utensils, I resisted him, and then he felled me on the ground and started assaulting me and suddenly poured a bottle of kerosene on me and set fire to my person from a burning open lamp. In a moment, fire engulfed me. Then Lodha pushed me out of the house. Then I raised alarm to save my life, and immediately thereafter, I became unconscious. On the following day, when I regained my senses, I came to know that I was in the hospital. After staying 4 or 5 days in the hospital in Dibrugarh, Lodha brought me to his house. As I did not recover, I said Lodha to inform the matter in the house of my mother. But Lodha did not do so. Later, when my elder brother came to know about the incident, he again got me admitted in the hospital. In the course of the incident, I sustained injury on my both the hands, neck, chest, and back. I'm not in a position to take food till date. I have been taking liquid food. Stringent action should be taken against my cruel husband, Lodha. So this is her statement, which she made on the 21st of May 2015, and ultimately she died on 26th of June 2015. Now, at page 30, your lordship will find the accused had adduced his evidence. Page 30. Well, before I take your lordships to page 30, my lord, from her 161 statement from the dying declaration, what it also appears that she also says that the incident had taken place on 15th of April, and 4 to 5 days, she was in AMCH, Dibrugarh. And then she was brought back. After coming back, she wanted to connect to her side of the family, which he did not allow, and ultimately he contacted. And the FIR seems to have been lodged on 21st of May. So probably incident took place on 15/4 only, it appears. Because the hostile witnesses have also said 15/4. Perhaps her brother sisters may have exaggerated that part, because they say 1 month ago. That doesn't fit with the other evidences. Anyway, my lord, this is how I am perceiving in the matter, my lord. I leave it to your lordships. Then page 30. Page 30 is the accused, my lord, DW1, defense witness 1. The deceased Rita Mura was my wife. One day in the year 2014, while I was out of my house for my daily wage work, my wife was cooking food in the house. Then she caught fire and sustained burn injuries. My neighbors informed me about the said occurrence, and then I came home. On reaching home, I saw that my wife Rita Mura was lying on the courtyard of the house. I saw that she had sustained burn injuries on her body. I accompanied my wife to the hospital in an ambulance. I took my wife to AMCH Dibrugarh. My wife was admitted in the hospital for next 1 month. I had my wife discharged from the hospital as I was financially unable to pay for her treatment. The doctors issued discharge certificate and other documents. Thereafter, the brothers of my wife took her to St. Luke's Hospital for treatment. They also took away the documents issued by the AMCH Dibrugarh. I paid rupees 3,000 to them for the medical treatment of my wife. While my wife was being treated at St. Luke's Hospital, I was arrested by police, and while I was in the judicial custody, my wife had died. I had a very cordial relationship with my wife. We never had any quarrel. The documents which were issued by the AMCH are not in my possession, as because the brothers of my wife are in possession of those documents. Then during cross, I am also known by the name Lodha Mura. The occurrence took place at the time of Bohag Bihu. It is not a fact that on the day of Bihu, I had mercilessly beaten up my wife and burned her after pouring kerosene upon her. My wife died after sustaining burn injuries. It is not a fact that I have deposed false evidence by stating that my wife caught fire while she was cooking food. It is not a fact at the time of occurrence I was present in my house. It is not a fact that today I have deposed false evidence to save myself from being punishment. So during Kamalot, the accused has taken the defense that he was not in the house during the time of the incident, and he says that he was informed by his neighbors. However, no neighbors has been brought as evidence to support his statement, support this part of his defense. There is no other independent witness to support him except his own evidence. In 313 also, he says the same things, the answers, that quarrel, however, he admits to the second question at page 32, if your lordship kindly see the last answer, quarrel took place occasionally. So there is an admission that there are quarrels, but which is of course common, perhaps a little common in relationships. Then your lordship will find at 34, he admits that. So that is all in 313, nothing substantial. So my lord, these are incriminating circumstances, if I may say, which are before your lordships, are basically the evidences of PW2, where PW2 says that they quarrel, number one. Number two, that the victim has reported to him that the husband accused burned her by kerosene, and that there is another second family of the accused. These are three incriminating circumstances which comes out from PW2, who is the informant. This is supported by PW3 and PW4 to the extent that there are quarrels and that she has said to even to 3 and 4 that the husband put them on fire. However, the police, according to the police, these were not said before 161. Then finally, finally the dying declaration, if I may say so, my lord, which was given to the police, because that was given on 15 and 26, she died, my lord. There she admits. Normally, police officer, that also there is no independent witness, but be that as it may, the police officer has confirmed that in his statement, so that evidence perhaps can be also relied. But these witnesses, if your lordship sees, perhaps a chain is formed. The only thing is PW2, 3 at that time didn't say. So what is before your lordship is perhaps only the dying declaration. So whether that inspires confidence to sustain the conviction solely on that dying declaration, which otherwise is not taken before the presence of any medical officer. There is no certificate of a medical officer about the soundness of the mind of the victim. However, in certain situations that may not be also fatal. There are so many decisions even to that effect. So at the end of the day, the cumulative effect of all these circumstances, if leads to the conclusion alone about the accused, then of course the convictions will be sustained. But if there is any doubt or otherwise, because though a defense was taken that he was not there, neighbors have informed. Unfortunately, no neighbors have been brought in as witnesses to support that part, that they called him and then he comes. That part, there is no evidence. And the fact that he was there and the house is also otherwise proved because he was there while she was taken in the ambulance. He only takes her. So that is there. The quarrel part, apparently most of the people have said. So some quarrel possibly is always going on between them. And she also tells that in her dying declaration about the quarrel. So if the dying declaration, they believe that quarrel part also comes in. My lord, so this is all before your lordship. The hostile witness, if they wouldn't have turned hostile, there was absolutely evidence because they clearly heard the quarrel. After some time, they comes out and finds her burnt, lying in the courtyard. Unfortunately, now they've turned hostile, so that part will have to be left out because that can be only used for corroboration or so that contradictions.
No 164 state.
No 164 statement. I think the investigation is slightly flawed here. That in fact, because there was time when she gave her statement, that was on 15, so 21st. There was time. The police officer could have gotten magistrate and recorded that. That would have given more weightage to her statement because she ultimately died only on 26th. That could have been done. And of course, the PW, that the hostile witnesses, PW6, PW7, PW9, there also 164 could have been taken. That has not been done. And as regards whether she received treatment in AMCH Dibrugarh, that also nothing has come. So what actually about the time length? Some witnesses are saying 1 month prior to 15. And then there are other witnesses are saying, no, the incident took place only on 15. A little inconsistencies are there. Now, whether those would be fatal or not, that of course would depend on the cumulative effect of what has come out. A lot.
May please, your lordship. Here, of course, there is no quarrel with the proposition that a dying declaration can be the sole basis of conviction. But here is a case of oral dying declaration, not recorded by magistrate or the doctor. So oral dying declaration, Honorable Supreme Court has said that some corroboration, prudence requires that there are some corroborations. And here where the dying declaration is also recorded by the police officer. Now, how far dying declaration recorded by the police officer is reliable? Now here, dying declaration, as I can see from the evidence, PW 2, 3, 3 and 4. Dying declarations were only stated by these three witnesses, 2, 3 and 4. So 2, 3, there are some contradictions. Police personnel have said that he had not stated about the dying declaration to the police. The contradiction seems to be proved as per the Honorable Supreme Court's directives, that how can a contradiction is proved if a person does not say a particular statement in his 161 and that is put to him, and he says during his cross-examination, and he says, no, it is not a fact that I have not stated about the same to the police officer. Here is a case where the PW 2 and 3, when they were confronted with the dying declaration part that they had stated in their examination in chief, then they said that no, it's not a fact that I have not stated. But then what happens? The statement will be put to the police officer whether he had stated. Then the police officer says that he had not stated. Then the contradiction stands to be proved. So here, I have also checked the 161 statement of 2 and 3. They had not stated about the dying declaration to the police officer. So contradiction is proved. So we cannot go into the dying declaration as stated by 2 and 3. But PW 4, he had stated about the dying declaration, and that is not contradicted. This stands as it is, as he said during his examination in chief. And I have checked his 161 also. He had stated about the same. Lordship will go to PW 4, 2, 3, I'll not go. PW 4 statement, Lordship will go to the middle part of his statement. And it seems the incident had taken place on 15/4, although the things are not very clear. But what I can deduce from the evidence is 15/4 the incident took place. Thereafter, she was taken to the AMCH. Lordship perhaps is going through PW 4 statement.
Yes.
PW 4, Lordship will see, accordingly, myself accompanied by Kailash Orang, PW 2, and other family members had gone to the house of the injured. We found the injured lying on a bed. I asked the injured as to how she sustained those injuries. Initially, she was reluctant to disclose, but later on told me that her husband poured kerosene oil upon her and set her ablaze. At that time, her husband was not present in the house. We had gone to the house of the injured on 15/4. Already 15 days had elapsed. This is somewhat not very clear. 15 days have elapsed after she was blazed on fire. My house is situated so and so. On 15/4, I was informed that by the injured that after the occurrence, she was treated at AMCH, but later on she was brought back home. On 15/4, we decided that the injured should be admitted in the hospital. Therefore, Kailash Orang, accompanied by myself and other family members, brought the injured to St. Luke's Hospital, Tinsukia. So this 15/4 is cannot be correct. 15/4, in my humble submission, was the incident that had first taken place on 15/4. And thereafter, she was taken to AMCH and then she was brought back. When she was there at her own place, she informed her brother. Then brother Kailash, PW 2 and 3, those people came. And seeing her not in a very good condition, she was again admitted in St. Luke's Hospital. It seems this will be the correct version. 15/4, on 15/4, as PW 4 said, 10 days, 15 days had already elapsed from the date of incident. That seems to be not very correct. She was not perhaps, he was not perhaps correct with the timing. Krishna Orang, I'll just read out the 161 statement, if it at all makes a 161 statement. He said, Ghatana hoy 15/4, incident took place at 15/4. Heidina Hondia Homoyot, Asami Sanjeev Murai, Justice Kya will understand. Niece Potni Rita Murak, Jotukor Namot, ধন বিচাৰি শাৰীৰিক অত্যাচাৰ কৰে আৰু উগ্ৰ মূৰ্তি ধাৰণ কৰি ৰীতামোৰাৰ গাত কেৰাচিন তেল ঢালি জুই লগাই দিয়ে. So he said on 15/4 incident took place. Now he had not said that I have seen it. Perhaps this is a hearsay. He had heard it. He reached her later. আৰু উপস্থিত বিৰণ ধৰি ৰীতামোৰা গাত কেৰাচিন তেল ঢালি জুই লগাই দিয়ে. ফলত ৰীতামোৰাই গুৰুতৰ জখমী হয়. She was injured. She was kerosene was poured. She was set at blaze and then she got injured. Asami Sanjeeve Ritak চিকিৎসাৰ বাবে ডিব্ৰুগড় লৈ যায়. He also said that accused took her to Dibrugarh for treatment after the incident. যদিও আৰোগ্য নোহোৱাকে উভতাই আনে. So without she being cured, he brought her back. পাছত ৰীতামোৰাই নিজা ঘৰলৈ আহি লৈ পৰি থাকে. খবৰ দিয়ে আৰু জুই লগা বুলি খবৰ দিয়ে. Then she informed him. খবৰটো পাই মই আৰু কৈলাশ আসামী সঞ্জীৱ মুৰাৰ ঘৰত উপস্থিত হওঁ. So after they were informed, then they reached their place. আৰু ৰীতা মুৰাক জখমী অৱস্থাত পৰি থকা দেখা পাওঁ. So he saw her injured, lying injured. তেওঁৰ মুখ and she had injuries on her face and everywhere. আমি সঞ্জীৱৰ ঘৰত নি তেতিয়া ৰীতামোৰাক আমি আকৌ হস্পিটেলত দাখিল কৰো. St. Luke পাছত আমি ৰীতামোৰাক St. Luke হস্পিটেলত ভৰ্তি কৰো আৰু 50% burn injury. He talks about 50%. So it seems 15/4 the incident took place. She was taken to AMCH. She was treated, but without her treatment being concluded, and she was brought back. And it is in the evidence that there was shortage of money. And thereafter, she informed, and then she was again taken to the hospital. So and then I'll just read out that dying declaration part. In his 161 statement also, he said after that, Kali 26/5 tarikhe St. Luke burn injury mrityu hoy, she died. I got it somewhere. 50%. পাছত আৰক্ষী magistrate Rita Murak Mitode Asami Sanjeev Murak. She said, I read it somewhere that when she asked him, she said the facts. Tetia Rita Murak Putpus Korute, Lordship, this is the statement I was talking of. Tetia Rita Murak moi Putpus Korat, Hotona to moi Ullek Kora, Dhorone Biborito Korikoi. The way he said in his initial statement that 15/4 there was an incident. So when he asked her, she said the incident as I have narrated. So the dying declaration to PW number 4, it is not contradicted and it stands as it is. Lordship will go to PW 10 statement where the contradiction of 2 and 3 are proved. Lordship will go to page 27. He does not talk of PW 4, Krishna Orang. Since it's not a fact, he had stated. Page number 27.
Yes.
Initially, the PW 2 and 3, there are contradictions. 2 did not say stated to me. Say I had recorded statement of Kailash Urang on so and so. Witness Kailash did not state before me that deceased sister informed him that the accused had burnt her by pouring kerosene oil. Witness PW3 did not state before me that deceased Rita Mura informed him at St. Luke Hospital that the accused set her on fire. So PW4 statement of dying declaration stands. That is an evidence against the accused person. Now going to the statement of the police where he had recorded the dying declaration. Lordship had already seen page number 26.
Yes.
He had read yes, page number page number, I think this is, yes, page number 28. The further examination where he had stated about the dying declaration. of the victim. Page number 28, Rita Mora stated before me inter alia that accused had poured one kerosene oil, bottle of kerosene oil upon her with the help of a burning wick lamp. She was burnt. She also told me that immediately afterwards fire engulfed her body, and that time one Lodha pushed, Lodha is her husband, this is his another name. One Lodha pushed her out of the house. That is how her burnt body was found outside the house. People, while of course they had turned hostile, but they had said that her body was found outside at the doorstep. So this corroborates in a way. One Lodha pushed her out of her house. The victim also stated before me that she shouted for help, but she lost consciousness. She stated that she regained her consciousness next day. And Lordship has already gone through page number 69, where her 161 statement, where the dying declaration is present, is there. So coupled with the statement of PW4 and the police's statement, dying declaration cannot be said to be cannot be believed. It inspires confidence, and it can be believed because of PW4 and police statement. Now corroboration, oral dying declaration of course needs corroboration. Corroboration comes from so many evidences that Lordship had seen. There used to be quarrel. They used to quarrel very often. Even the accused said, the deceased said, the independent witness, the relatives had said that there used to be quarrel amongst them. There are demands of dowry also, that the brother had said immediately after the marriage, even in the FIR Lordship had seen, immediately after the marriage, there are demands for dowry. There were quarrel, and then after the occurrence, she called up her brother. In her 161 statement, she said that she wanted her mother to know after the incident, but the accused did not say. Then she informed her brother. Brother came after so many days. She was again taken to the hospital. Of course, 30% burn injury. And she died of septicemia. And she died after many days because incident occurred on 15/4 and she died on 25/6.
26.
25/6, 25/6 she died. 26/6.
26.
26/6. No, IO once said she died on 25. And then at one place I find it 26. Anyway, she died on 25, 26.
1 day only.
1 day only. So after more than a month, she died. 15/5 would be 15/5. No. After 2 months, more than 2 months, she died. In certain such cases, I've seen when the deceased dies after a very long period of time. Sometimes cases are converted because this is not an instantaneous death. It cannot be said to be a culpable homicide amounting to murder. So in those cases, few cases, when the person dies very late or he dies out of some other regions, then cases are converted to 304 or part 1, part 2, that will be seen with the intention. That, of course, that part is there, 35% burn injury, and she died after more than 2 months. So this oral dying declaration with the police's statement coupled with the corroborations, the culpable homicide is proved.
Yes.
And it was the accused who is the perpetrator. That is proved by these dying declarations. One fact that is stated by PW4, Lordship will see this, that initially she was reluctant to disclose the fact. He said in his statement, in his examination in chief, Lordship had already gone through that statement at page 15. Initially, when he asked her, she was initially reluctant to disclose, but later on told me that her husband poured kerosene oil. In this respect, I would like to place one judgment. I mailed it yesterday. Because in Honorable Supreme Court said that normally the society that we live in, the deceased or the victim, the woman, normally they do not want to accuse her husband at the first instance. Supreme Court said later on, when they realize, then they say it. So there is nothing wrong. We cannot presume that she had stated an incorrect statement or something because she did not say it initially. But Supreme Court said that initially it happens, the victim do not disclose. After a little thereafter, they disclose the name of the real perpetrator. There I would like to place one judgment. And they can take the printout. Lordship, I had sent it last night. This is
Your lordships will kindly excuse me for a minute.
there are in fact 3 judgments that I wanted to place. And maybe excuse me, it's taking a little time. Yes, it is. This one is 2010 8 SCC 514. 2010 8 SCC 514, paragraph 27. This is Lakhan versus State of MP. Paragraph 27, till they take it out, Lordship, I can just read the relevant lines slowly. I said, tinta will you? 2010 8 SCC 514. Here is a case where the deceased was burnt and she was taken to the hospital by her in-laws. And in that context, the Supreme Court said, and she did not accuse her husband at the first instance. Later, in her second dying declaration, she had stated that her husband had poured the kerosene. Now here, in that context, Supreme Court said at paragraph 27, Lordship got it? Paragraph.
Yes.
Initially, facts Lordship will see in paragraph 25. Undoubtedly, the first dying declaration had been recorded by executive magistrate immediately after admission of the deceased. Paragraph 25, Savita, in the hospital, and the doctor has certified that she was in a fit condition of health to make the declaration. However, as she had been brought to the hospital by her father-in-law and mother-in-law, and the medical report does not support her first dying declaration, the trial court and the high court have rightly discarded the same. Even before us, Lordship need not go into that. This is what she had stated. Lordship will come to paragraph 27. In the instant case, deceased Sabita was brought to the hospital by her mother-in-law and father-in-law, and she was under their influence. The trial court is right in making an observation that generally, most women do not accuse their husbands for sentimental and religious reasons. This is what normally happens, but in this particular case, second dying declaration, she has named her husband. This is for this particular line I'm relying on, where PW4 stated, initially she did not, later on she said. The second judgment, Lordship. The second judgment that I would like to place is on the certificate of fitness, because the police said that I have not. I have simply taken for permission of the doctor, but there was no certificate of fitness. In that respect, Honorable Supreme Court said that this is not a mandatory requirement. As far as there are witnesses, seeing her tells that she was, they recorded, and if the magistrate recorded, it can be presumed that he knows that he was in a fit state of mind. That is how she had stated, and he recorded. Because he has no animosity with the deceased. Nobody has. The police officer or the magistrate or the doctor will never have anything against the accused. In that respect, Lordship will see judgment of Lakshman versus State of Maharashtra, 2002 6 SCC 710. 2002 6 SCC 710. It's a small judgment. Lordship will go to first paragraph 3.
Yes.
Paragraph 3, Lordship got it. The justice theory regarding acceptability of a dying declaration is that such declaration is made in extremity when the party is at the point of death and when every hope of this world is gone, when every motive to falsehood is silenced, and a man is induced by most powerful consideration to speak only the truth. Notwithstanding the same, the great caution must be exercised in considering the weight to be given to this species of evidence on account of the existence of many circumstances which may affect their truth. The situation in which a man is on a deathbed is so solemn and serene is the reason in law to accept the veracity of his statement. It is for this reason the requirements of oath and cross-examinations are dispensed with. Since the accused had no power of cross-examination, the court insists that dying declaration should be of such a nature so as to inspire full confidence of the court in its truthfulness and correctness. The court, however, has to always be on guard to see that the statement of the deceased was not as a result of either tutoring or promoting or a product of imagination. The court also must further decide that the deceased was in a fit state of mind and had the opportunity to observe and identify the assailant. Normally, therefore, the court, in order to satisfy whether the deceased was in a fit mental condition to make the dying declaration, look up to the medical opinion. But where the eyewitnesses state that the deceased was in a fit and conscious state to make the declaration, the medical opinion will not prevail, nor it can be said that since there is no certification of the doctor as to the fitness to the mind of the declarant, the dying declaration is not acceptable. A dying declaration can be oral or in writing or in any adequate method of communication, whether by words or by signs or by otherwise, will suffice provided the indication is positive and definite. In most cases, however, such statements are made orally before death ensues and is reduced to writing by someone like a magistrate or a doctor or a police officer. When it is recorded, no oath is necessary, nor is the presence of the magistrate is absolutely necessary. Although to assure authenticity, it is usual to call a magistrate if available for recording the statement of a man about to die. So here the other point is also answered, because here is a case where magistrate was not called to record the evidence, the dying declaration. Now it's a situation where the person is burnt only 35%. Perhaps the police also didn't think that she will die, and she has been surviving since so long. So there was no, therefore, I think there was no initiative on the part of the police officer to record it, to bring a magistrate. Can be a explanation to that. Here, so it is said that always recording by a magistrate is not required. For that, I'm placing another judgment as well. Where it is when it is recorded, no oath is necessary, nor is the presence of a magistrate is absolutely necessary. Although to assure authenticity, it is usual to call a magistrate if available for recording. There is no requirement of law that a dying declaration must necessarily be made to a magistrate. And when such statement is recorded by a magistrate, there is no specified statutory form of such recording. Consequently, what evidentiary value or weight has to be attached to such statement necessarily depends on facts and circumstances of each particular case. What is essentially required is that the person who records a dying declaration must be satisfied that a deceased was in a fit state of mind. Where it is proved by the testimony of magistrate that a declarant was fit to make the statement, even without examination by the doctor, by the declaration can be acted upon, provided the court ultimately holds the same to be voluntary and truthful. A certification of the doctor is essentially a rule of caution, and therefore the voluntary and truthfulness nature of the declaration can be established otherwise. Then Lordship will go to these two decisions that the apex court had relied on. Rasamma, and not go into the same points, they have again reiterated. Dying declaration in question has been recorded by judicial magistrate, had made a note on the basis of the elicit answers. Lordship may not go into. This would suffice the case in the instant case that dying declaration, the requirement that Lordship will have to see a certificate of fitness is not there. Here, police officer had said, I went there on 21st. I found her on the bed, and after taking permission of the doctor, I have recorded. So we cannot deduce from this particular fact that she was not in a fit state of mind. And the third point, of course, that has been answered in this judgment also. But I had referred to one more judgment of 83-1 Ranavati, where it is said that statement recorded by police will also do if statement is not recorded by the magistrate or the doctor. That Lordship will find 1983-1 SCC. Janupai. Lakshman was 5 judges. This one. Ranavati. This is by 2 judges. Lakshman was by Constitution Bench, the earlier judgment that your Lordship has read. Here, Lakshman, yes, 2002-6 is by a Constitution Bench. This is, of course, by a 2 judges bench. Now, here, Lordship will go to paragraph 5 and 7. 83-1 SCC 211. 211. Paragraph 5 and 7, Lordship will go to. 5, here is a case where the dying declaration was recorded only by the police officer, not by magistrate or the doctor, and that was held to be correct. Number 5. Paragraph number, before the learned session judge, the main contention of the appellant appears to have been that the case of prosecution has not been properly established. It appears that the very same arguments were advanced before the High Court. The main argument before the High Court was that the session judge went clearly wrong in placing any reliance on the statement alleged to have been made by Savitri Devi to the police officer and recorded by the police officer. She is the one who died, Savitri. It was argued before the High Court that no reliance could be placed on the said statement, which was considered to be the dying declaration of the deceased, as the statement has not been made to a magistrate but to a police officer, and the facts and circumstances of the case would indicate that Savitri Devi was not in a fit condition to make any statement at all. The second argument need not be gone into. It had been further argued that there was no corroborative evidence of the said statement, and in the absence of any corroboration of the dying declaration, conviction of the appellant only on the basis of dying declaration could not be justified. The High Court in its judgment had carefully considered the arguments at length and considered all the facts and circumstances of the case and the materials on record. For reasons recorded in a carefully considered judgment, the High Court negated the contentions and held the appellant guilty and dismissed the appeal. Lordship will go to paragraph 7 now. 6 is basically the facts of that particular case. 6, or Lordship can also read. The main argument advanced before us in this appeal on behalf of the appellant is that the statement made by the deceased to the police officer, which has been recorded by the police officer and which has been relied as a dying declaration of the deceased, is not admissible, and in any event, no reliance should be placed on the same. It has been argued that dying declaration which can be relied on as an evidence must be made to a magistrate. And it has been further argued that in view of the physical state of the deceased at that time, when she is supposed to make this statement to the police officer, the said dying declaration is of no evidentiary value. It has been submitted that no explanation was offered on the behalf of the prosecution why the declaration could not be made made in the presence of the magistrate. It is also the submission of so-and-so. Lordship can skip that. Paragraph 7, Lordship will come. In our opinion, neither of these two judgments that in the first paragraph it was relied on by the appellant is of any assistance in the facts and circumstances of the case. These decisions do not lay down, as they cannot possibly lay down, that a dying declaration which is not made before a magistrate cannot be used in evidence. A statement written or oral made by a person who is dead as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question, becomes admissible under 32 of the Evidence Act. Such statement made by the deceased, commonly termed as dying declaration. There is no requirement of law that such a statement must necessarily be made to a magistrate. What evidentiary value or weight has to be attached to such statement must necessarily depends on the facts and circumstances of each particular case. In a proper case, it may be permissible to convict a person only on the basis of a dying declaration in the light of the facts and circumstances of the case. In the instant case, the dying declaration has been properly proved. It is significant to note that in course of cross-examination of the witness proving the dying declaration, no questions were put to the state of health of the deceased and no suggestions were made that the deceased was not in a fit condition of health to make any such statement. The doctor's evidence also clearly indicates that it was possible for the deceased to make statement attributed to her in the dying declaration in which her thumb impression has been affixed. In the instant case, it cannot also be said that there is no corroborative evidence. Evidence of 1, 4, 5, and 8 clearly corroborates the statement recorded in dying declaration. We do not find any material on record on the basis of which this testimony of these witnesses can be disbelieved. It may be noticed that none of these witnesses, including the police officer who recorded the statement, could be attributed with any kind of ill feeling against the accused. The High Court has elaborately dwelt on this aspect and has carefully considered all the materials on record and also the arguments advanced on behalf of the appellant. We are in agreement with the view expressed by the High Court, and in our opinion, the High Court was right in upholding the conviction of the appellant. So here, all the questions regarding the fitness, regarding the recording by the police officer is answered. There is no requirement that magistrate has to do. Of course, one judgment, Honorable Supreme Court has said at least some reason has to be shown that why magistrate was not brought. That, of course, is there. It is not encouraged unless it is shown that recording of by the doctor or the magistrate could not be resorted to. That part is there. Here, what I can say from the evidence, since a long period of time has elapsed from the date of the occurrence, and it was only 35%, nobody could deduce that she will die soon. It is, that is the reason why a magistrate or a doctor was not brought. The police officer's statement is there and it's reliable. These are my humble submissions, Lordship. These are my humble submissions.
Just two things, madam. PW4 evidence, if your Lordship kindly come to at page 15, because as pointed out by my friend Palak, PW23 goes. Now PW4, since there is no state, the police doesn't say that she didn't say, therefore she says that PW4 stands. But if your Lordship kindly come to the cross part, there your Lordship will see police never recorded my statement. Has your Lordship got that? So perhaps her 161 was not taken, my lord. And she was only examined before the court, my lord.
No, 161 is there, I read out.
We read it.
It was no?
Krishna Ora?
Yes, I'll show you.
Okay, my lord, then I stand corrected.
161, the one that I've just read, অসমীয়া যে পঢ়িছ না?
It is there, Assembly.
Krishna, yes, sir. Statement
It's all
of
right, it's
Krishna.
all right. If it is there, it's there, because I got confused of what was mentioned here. Police never recorded my state.
This statement was little late. I mean, the date when other witnesses were examined, those were little earlier, prior.
It was the date when her statement was taken.
No, I mean, the 161 statement was recorded of Krishna Ora on 26/6/2015.
Okay, after she died.
After she died. 26/6.
26. Your lordship may just keep that noted, my lord. That was, her statement was recorded on 26/6.
On the date or after she died?
FIR was lodged on 21/6. 21/5, no? 21/5.
5.
FIR was lodged on 21/5/15. Investigation was done that time itself. It is mentioned the other witnesses, their statements were taken on 21st/5 only.
Yes.
And her PW4 statement was taken only on 26/6.
6.
Now, as per just one decision, now there is no quarrel to the fact, my lord, that a statement, if is recorded, dying declaration recorded by the police officer, will not be acted upon, because section 32 is the answer. This is an exception. So if, and 162, it is also mentioned that it will be excluded. So there is no difficulty to that part, but how it will be used, my lord, that is the question. Because even one of the decisions which my learned friend was reading, I remembered, in fact, I also mentioned that certificate of fitness and all may not be required, but at least a question needs to be put whether she is in sound state or not. This was also not done in this case, my lord. There is nothing mentioned whether at the time when she gave that statement, whether she was in a sound state of mind, whether voluntarily she has given. Such questions also not put. It is just a very technically that 161 statement was taken, and later after her death, it has become a dying declaration. This is how it has happened. Now, one decision that I would like to rely upon is that famous Dalip Singh's case, my lord, from state of Punjab. This is a 3 judges bench. This is AIR 1979 Supreme Court at page 1173. My office has already given print.
So Judge says the reason has to be shown why magistrate was not brought.
Relevant paras are 7, 8, and 9. I will just read para 8 a lot. Citation is AI 1979 Supreme Court 1173. Dalip Singh versus State of Punjab. This is the 3 judges bench. Paragraph 8. If your lordships kindly come to.
79/4 SCC.
I think 2 copies are available.
Yes.
Yes. There were 2 dying declaration of Ram Singh, one oral and the other written, which was recorded by the Assistant Sub-Inspector of Police, PW 28 on 12/12/75. The oral dying declaration was made to PW 11 Tara Singh. Neither of the dying declaration was relied upon by the High Court because he had named Baldev Singh also. We may also add that although a dying declaration, this if your lordship I kindly see, we may also add that although a dying declaration recorded by a police officer during the course of the investigation is admissible under section 32 of the Indian Evidence Act in view of the exception provided in subsection 2 of section 162 of the Code of Criminal Procedure 1973, it is better to leave such dying declarations out of consideration until and unless the prosecution satisfies the court as to why it was not recorded by a magistrate or by a doctor, as observed by this court in so and so, the practice of the investigation officer himself recording a dying declaration during the course of investigation ought not to be encouraged. We do not mean to suggest that such dying declarations are always untrustworthy, but what we want to emphasize is that better and more reliable methods of recording a dying declaration of an injured person should be taken recourse to, and the one recorded by the police officer may be relied upon if there was no time or facility available to the prosecution for adopting any other better method. But I am only on that point. In this case, no explanation, nothing. Because as your lordship have seen, there was considerable time from the statement given by the victim for getting it recorded by a magistrate, which was not done. It could have been done. And why it is not done is also not stated. There is no question put to the police officer by the court, trial court, neither does the police officer on its own says anything. We can assume a lot of things, why it was not done. And the only corroboration which is available on the record is the evidence of PW4, which was also not recorded immediately. So these are the facts before your lordship. It's ultimately a case of circumstantial evidence. Therefore, it has to be proved beyond reasonable doubt by the prosecution itself that there is no other views except what is presented here. No scope of any other involvement. The accused has already given his evidence where he has given one version. So there are apparently two versions available on record. Now, if there are two views, generally it's acquittal. I leave it to your lordship. Yes.
That non-recording of the magistrate or the doctor is only the reason that I can say is because of the length of the time. Nobody thought she'll die, perhaps.
That's what I
No
said. We can
reason-
assume all this.
No reason, of
We
course.
can only assume.
Only
today
an assumption,
that-
because nothing is discernible from the records. If we can only.
It should have been ordinarily put to the police officer by the court below, or the police officer should have come up with an explanation. Because neither does he collect any information from Dibrugarh Hospital. Because that would have given a clue as what treatment did she get when she was gone to the Dibrugarh Hospital, because it could be a case that she died because of lack of proper treatment. That could have been also a situation. Deeply obliged, my lord.
And conversion, of course, conversion, because there are evidence that she could have perhaps be saved. Because she was brought back before her treatment was over. This is what is there in the evidence from AMC.
Decision to analyze.
So conversion can be a way out. However, he did not argue on that conversion to. But facts of the case.
But there is one decision on circumstantial evidence about two views. That is 2009 volume 13 SSC at page 740. I'm not relying, I'm not reading it, my lord. Your lordship may just keep a note. It's paragraph 11. They have discussed everything in details in para 11. 2009, volume 13, SSC 740. From paragraph 11 starts at page 743, and then they quote which starts from 12. Basically, they should exclude every possible hypothesis except the one to be proved. So there can't be two views.
Yes. Jay Goswami, then let's make a query. Also heard as Jahan. Leonard addition.
Take the
Yes. Okay, completed. This one.
Deeply obliged.
Obliged.
Simple mechanism.
Inform me of our phone immediately. So kindly fix the matter on the Monday or 24th of May. Monday is available. 8th of May,
On request, on behalf of Mr. Didas,
Didas.
Digedas.
Yes, sir.
Digedas, then the counsel for the petitioner. Is the matter on 24th.
Monday,
Monday. There'll be some difficulty.
24th of May.
24th. Can you hear me? Yes.
24th of May.
Yeah.
Must have lost.
I think this argument is over.
Yes.
Over. Okay. Do they have some difficulty? I'll just reserve it and I'll put on.
Mine.
Heard, Mr.
All is good.
All Oscar, Leonard Council. For the petitioner in WBC 526/2022 and 2312/2022. Also heard Mr. MS Rajbhoyan, Leonard Council. For the petitioner in WBC 782 of the 2022. Also heard Mr. R. Majumdar, Leonard Standing Council, Elementary Education,
Yes, I.
and MS T. Sutia. S. Sutia.
Yes.
Leonard. You are the
For my SSA, server 6
Leonard Standing Council, SSA. NCT, I alarm was there, isn't it? I alarm or
The other day he was there.
just check up for NCT. Hearing concluded, just one minute.
Item 5, ordered.
Like.
Net
This is an old one.
Well,
Old notice.
My lord, this I has been filed, my lord, for suitable correction, my lord.
What correction?
My lord, here lordship says, excellent, my lord, petitioner, my lord, was appointed as gate for employee, my lord. He is a non-teaching staff, my lord.
Hmm.
My lord,
Where's the adjustment?
order is at place, my lord, 8, my lord.
Hmm. What is the problem here?
Now, here kindly we come to page 9, my lord, paragraph 3, my lord. Here, my lord, the court has directed section 14 of this Act of the Assam Consolidation of Service of Teacher and Reorganization of Educational Institution Act 2017. My lord, this act is for my lord teaching staff, my lord. And my case is covered by the non-teaching act, my lord, of 2018, my lord. That is why, my lord, my case, this act should be changed to the Consolidation of Non-Teaching Act, my lord.
Where is that?
My lord, I had a state in this, my lord, here also. Assam Education Manual. Yes.
Then you should file a review.
Not only just correction will be only this act. In fact, my lord, in this provincial act itself, my lord, there is two acts were there, my lord. There's in order.
Yes, show me. Which act?
My lord, act, my lord, the Assam Education Provincialization of Service of Non-Teaching Staff of Bhansar Education Institution Act 2018.
Page.
Yeah. My lord, page 57, my lord. It is 87, my lord.
Yes. Does this also file for, provides for an appeal?
Yes, yes, section 14, my lord. Here, my lord, lordships, my lord.
No, no, no.
Oh,
section
that
40
provision, my lord.
Yes,
Yes, yes, there is also a provision, my lord. I can. Appellate authority, section 8, my lord.
section.
Section 8, page 95, my lord. Appellate authority.
You are non-teaching employee,
Yes, my lord.
non-teaching staff,
My lord, date for employment.
but of venture educational institution.
My lord,
Anybody for respondents?
education department, secondary education.
Yeah, pray.
Yes, my lord. This is a secondary matter, my lord, but no one has come that time.
Who's for the secondary education?
Khatamir is there, my
Who?
lord. R. Mazumdar is also there.
Who is Mazumdar?
He's on election court number 7.
Then let him come.
My lord.
You will take up at 2. Or if he's
Or,
not,
my lord, I can call someone. I may be allowed to call someone, my lord, now.
yes, you can call.
In fact, my lord, uh, the order by which, my lord, the teaching and non-teaching staffs were coincided, my lord. The order dated 4th February, my lord. The order itself, my lord, contained, my lord, 2 acts, my lord. In fact, there is a, my lord, and the original petition also.
Yeah, original writ petition. Where? Page?
It is page, my lord, 24, my lord.
Have you got a copy of this? Is it okay?
Yes, sir. No.
Hurt Mr.
Yes, sir.
S. Hawk, learned counsel for the petitioner. Also hurt Mr.
B. Kaushik, my lord.
B. Kaushik, learned standing counsel,
Second.
secondary education. For the respondents.
Installment. Number 1, 2, 3.
1, 2, and 3, my lord.
1, 2, and 3. No. By this application, the applicant, who is the writ petitioner in WBC number
6316.
6316/2021, is praying for correction / modification of paragraphs
3 and 4.
3 and 4 of the order dated 2/3/2023, passed in WBC 6316/2021. Stop. It is the case of the applicant that he is a non-teaching staff of
Brahmaputra Valley,
Brahmaputra
Valley Senior Secondary
Secondary School,
Kanara, Barpeta.
Kanara, Barpeta. And therefore, this case falls under the Assam Education Provincialization, within bracket, provincialization of services of non-teaching staff of vendor education, educational institutions, close bracket, Act 2018. Stop. And not under the Assam Education within bracket provincialization of services of teachers and reorganization of educational institutions of close bracket Act 2017. Stop. And on this ground, comma, the applicant prays for modification of the paragraph 3 and 4 of the said order dated 2/3/2023. Stop. After hearing the parties, comma, and on consideration of the materials available on record, this court is of the considered opinion that that there was an inadvertence in the paragraph 3 and 4 of the order dated 2/3/2023, passed in WBC 6316/2022. Stop. Accordingly, comma, order and paragraph 3 and 4 of the order dated 2/3/2023, passed in WBC 6316/2021, is accordingly modified, and the same shall read as under. Just put in inverted commas, paragraph. Section 8 of the Assam education within bracket provincialization of services of non-teaching staffs of vendor educational institutions, close bracket Act 2018, within bracket Act of 2018 in short, provides for appeal before the state government on the recommendation of the state level scrutiny committee. Stop. Para 4. Accordingly, petitioner is directed to file an appeal under section 8 of the Act of 2018 before the state government appellate authority within a period of 1 week.
1 week.
1 week from today.
Nice.
Stop. Thereafter, comma, on receipt of the appeal, comma, the appellate authority shall hear the petitioner as well as the response number 5 in person, and thereafter dispose of the appeal by a speaking order and in accordance with law within a period of 2 months from the date of receipt from the date of receipt of the it will be from the date of receipt of your appeal
Appeal along with the certified copy of this.
from the date of receipt of the appeal to be filed by the petitioner along with a certified copy of
Right.
this order. I is accordingly disposed of.
Hello. Obliged.
Majumdar, just reserves adjustment. I
Yes,
was
sir.
thinking of dictating it. Some difficulties.
I apologize, that I was not here when the matter was, I'm sorry.